Hello everybody, today we're going to be going over Chapter 3. Chapter 3 covers our medical, legal, and ethical issues that we have to work under as EMS professionals. So we're going to be going over what the scope of practice is, issues that we can have with consenting patients as well as refusals on in various age ranges, go over some of the legal aspects that we have to worry with, such as HIPAA, EMTALA, negligence, and how you can protect yourself. Every single call that we go on to, whether it's a trauma, medical call, uh, a lift assist, no matter what, there's various legal and ethical issues that we have to work through. Um, Most of the time, these are pretty clear. Sometimes they're not. You know, should you stop to help someone who's been in a motor vehicle accident even if you're on duty? Or excuse me, if you're off duty? Should you treat a child when their parents aren't there? So we have to be able to weigh all of this information so that way we can make sure that we act in our patient's best interest. There's two things that we have to work under. We have our scope of practice and our standard of care. Scope of practice is what our state allows us to do, whereas scope of practice is what somebody who has the same licensure, the same training, ensuring that they're giving the same standard of care. Okay? Excuse me. So as I said, scope of practice, that's what we are legally obligated to do within our state, and each state varies. You have your medical director that at the state level that makes our state protocols, but then you can also have a localized scope of practice, and because your primary medical director, your service medical director, they can alter some things also. Such as, for example, the state for paramedics, the state allows us to give morphine or used to allow us to give morphine for chest pain patients. Now, if our medical director did not want us to do that, all he has to do is not authorize us to purchase that medication, and now it's outside of out of that service's scope of practice. So be aware of not only what your state scope is, but as well as your local scope of practice. Standard of care, there's two principles that we have that is followed. Did you provide the right assessment and care? And did you also perform the correct assessment and care? Okay. So not only do you want to make sure that you're doing the right assessment. So like if you have a medical patient and that is complaining of chest pain, you would want to make sure that you focus on the chest, not their abdomen or their leg. Okay? You want to make sure that you are doing the right assessment for that patient and also providing the correct care. For legal duties, we have to have a legal duty to act. That this ensures that we are providing the correct service, whether or not we think that the patient needs an ambulance or not. That is not our position to make that choice. We respond when people feel that they need help. Excuse me. Like I said, there has to be some legal obligation to provide service. So you have to be on duty in order to have a true duty to act. If off duty and you're non-functioning in an EMS capacity, most states we don't have a legal obligation more than any other citizen. However, if you do happen to stop, stop and help them, any of the victims on the scene at the basic level, um, you know, if you happen to pass the scene, you know, even if you don't want to stop, hey, call for help. If you pass the scene and make no attempt to call for help, guess what? You're still not in trouble because you didn't have any legal duties. So be cognizant of what your service is available to do. Um, Even if you do happen to stop and you do make patient contact, you still have to maintain confidentiality of the patient. So if you happen to take notes of everything, make sure that you turn that over to um, whoever responds to it. However, there's a catch. If you are a higher level of practitioner, such as let's say you go on to advanced or you go on to paramedic, get your license, and it is a let's say a cardiac arrest, and a BLS crew arrives and there's no medic on duty or medic on the truck, you have a responsibility to ride in. You can't turn over care to that patient. Excuse me. But ultimately, you have to remember you have a duty to your own self, so your own safety, a duty to your partner to ensure that everybody is responsible and safe, but you do have a duty to your patient as well as to your equipment. Um, if you don't have the capabilities to handle something, call out of service, get it fixed, and then take the next call. Good Samaritan laws, these protect anyone who is not getting paid for their services, um, as long as you are acting in good faith. So if you happen to stop at that motor vehicle accident and something happens, patient gets hurt more, as long as you can prove that I did that in good faith and I didn't purposely try to hurt the patient, you're protected. However, let's say you show up to a car, the car, patient got into a minor accident, and patient's fine, they're not critical, they're complaining of neck pain, and you just walk up to the car, grab them, and pull them out of the vehicle. Now you're liable for gross negligence, because as a provider, you're trained on how to properly assess your patient. So if you just reach in and grab them out, and you don't do a proper assessment, you could have potentially have just hurt, further damage to their neck. So make sure if you go to them, keep your training in mind. As I said, you have to, render your care the best of your ability. Make sure you act professional when dealing with your patients. And ultimately work within your scope of practice. Whether you're an BLS or an ALS provider, if me as an ALS provider, if I show up a to an accident, I don't carry a jump bag, I don't carry a cardiac monitor in the back seat of my truck. It's hell of expensive. But so since I don't have that equipment, I'm just going to work within the basic EMT scope of practice. You know, do a good assessment. If I have the ability to, I'll start splinting out on the scene while I'm waiting for EMS to respond. We also have sovereign immunity that is afforded in certain cases to government employees, such as military. Um, they can be a little, if they, that's what, excuse me, I'm getting tongue-tied here. Usually in the event if they are involved with something, they're covered. Um, I know with Lifeline, for example, they generally won't assist with or civilian personnel. Also, if a government EMS service, like I said, such as Lifeline, if they would happen to respond to a civilian, and military personnel treat them, they're covered within civil from being civilly sued. Now they do have a specific amount of time before they can sue. That's your statute of limitations. It can be anywhere from 5 to 10 years, if not longer, depending on what it is they're wanting to file a lawsuit for. Medical direction, those are the ones that have a legal right to function as the EMT. They make the choices who can or cannot do. They have to sign off on our CEUs or our continuing education, our skills every 2 years. They make our any standing orders, protocols within our local service as well as at the state level. This is usually a medical physician that we have to have some form of MD over us in order for us to be able to serve our local communities. When we are responding with them, we have to make sure that we follow all approved standing orders and protocols. Make sure if you're wanting to give any procedures that um, that are considered category B within your protocol that you call med control, speak with them, let them know what's going on, why you're wanting to give that medication or do that procedure, and they let you know whether you can or cannot. If you have any questions about anything that's going on, whether you should treat this or whether you should transport the patient or not, call them. When in doubt, call them. We also have ethical responsibilities that we have to be aware of also, and it goes into not only ethics but morals. You know, what's right and what's wrong. And it varies from person to person. However, ours is, we want to serve the needs of the patient. What is wrong with our patient? We want to try to do whatever we can to make them comfortable, to make them better, to where they can progress. We want to make sure that we report, when we give our reports to everybody, that we're being honest. We don't want to lie about anything. If there's any changes in EMS, we want to make sure that we are taking care of it. This is also that way we can make sure that we're ensuring the best medical care for our patients. Competent patients do have the right to accept or refuse emergency medical care. In order for them to be considered competent, they have to be fully alert and oriented, be able to tell you what today is, where they're at, what's going on, and they have to be aware of the risks of not going to the hospital. Now, generally, if we go to somebody and it's just a lift assist, if there's no obvious injuries to them, it's pretty cut and dry. However, the chest pain patients that don't want to go to the hospital and you're afraid that they may be having a heart attack and they're just continuing to refuse, you want to make sure that you say, hey, if you don't go to the hospital and you are truly having a heart attack, there is a chance that you could potentially die. Make sure that they what I usually do is I make sure that they say that back to me so that way I know that they're, excuse me, completely understanding what I'm trying to tell them. Before you touch them, you want to make sure that you have some form of consent. If they're whether it's informed, expressed, whatever, uh, they can do it simply by nodding their head or sticking their arm out when you ask if you could check their blood pressure. That would be your express consent. Informed consent is when you explicitly tell them what you're wanting to do. Sir, I'm going to check your blood pressure real quick. It's going to get a little tight on your arm, but it will let go. But I just need to see what your blood pressure is to make sure that everything is okay. Um, and then if he says, okay, that's fine, you have his informed consent. Implied consent is the consent that you would, when you're treating under the guise that they would want you to do this, such as a patient who is unresponsive and is unable to make their own decisions, or if they are disoriented from after having a head injury, you would assume that they would consent to emergency care if they could. Call the hospital, let them know. They may give you orders to restrain the patient if needed. Minor consent, that's for those patients that are under the age of 18 that are unable to make their own legal decisions. So we want to make sure that we have contacted a parent or guardian um, and make sure that we have permission to treat that patient. Now, this can vary from state to state on how old the patient has to be in order to be able to consent to any type of treatment. For example, in the state of Alabama, they can be as young as the age of 12 or 13, to consent to treatment. So they can say, yes, I want you to treat me as young as the age of 12, 13, somewhere around there. I can't remember off the top of my head. But they cannot consent to refusing treatment until they are 19 years old. So if we go to a 14-year-old and they're like, no, I don't want to go to the hospital, I just got a headache, we need to make sure that we call the parents and talk to them first. Now, if they consent, then we can transport. Okay? Involuntary consent, those are for those patients that are incarcerated or the ones that are imprisoned who are under the state of either local PD or the state. They cannot consent to going to the hospital or not. Now they can say, yes, I want to go. However, if the jailer says no, we'll transport them to the hospital in the back of the squad car. They do have that right. We just want to make sure that we fully describe what's going on to the officer. Advanced directives, these are what patients are able to decide on for any treatments that they would like if they know that they become, if they know they are or if they ever happen to become chronically or terminally ill, on whether or not they would, what kind of resuscitation they would want, what kind of treatment they want. So that way they take those decisions out of their family. You know, that way it's cut and dry as to what they would want. Because it's a very hard decision when it's their loved one or when their children, their wife, their family, whoever is having to make that decision on whether or not to end their loved one's life. We can have a do not resuscitate order. These are the ones where uh, if they don't want any type of resuscitative efforts done, they don't want CPR, no intubation, no nothing like that, they would have to have this signed. They can have a living will. This would state what kind of treatment they would want. They may just want comfort measures only. They may not want any kind of cardiac, do CPR, but no cardiac medications. That kind of information would be listed in there. Healthcare proxy or healthcare durable power of attorney. This is somebody that is legally authorized to make any healthcare decisions. This has to be signed usually by a probate judge. It can be signed by a probate judge, or it could be signed over quickly in the hospital, but that's usually on a temporary basis. So usually for a fully POA, you'd want to go to the judge and get this signed off. Um, Physician's order for life-sustaining treatment. Um, this is usually those that have some form of serious or terminal illness who they don't expect them to live more than a year. So usually, once again, this is kind of like a DNR. This is the one where if they would want something else done, um, such as continuing life-sustaining treatment. However, if their heart stops, they may not want anything, or they may not want to be intubated or have medications pushed, something along those lines. If you ever do have a DNR order, you want to make sure that everything is filled out properly. Get my laser pointer. So you'd want all of this information to be filled out, patient's demographical information. They would want, you have to have what kind of order that this is, whether it's a full DNR or if it's some form of living will. The physician's information all needs to be filled out, their spousal information, and then ultimately it needs to be fully signed. If any of it is not completely filled out, if the physician hasn't filled it out or if hasn't signed it, um, it is not a legal order. I had this happen to me. I went to a patient who was in cardiac arrest. Family was like, he doesn't want this. He's a full DNR. However, when they brought the DNR, finally, they couldn't find the DNR at first, so we started the resuscitative effort. We started putting IVs in, we intubated him, we worked it like we would a normal code. Well, then they came out with the DNR order. Well, the patient had signed it, the nurse had signed it, but the physician hadn't signed it yet. The physician was actually supposed to come later that day, and he was going to sign the DNR order. So we had to continue working the code. We ended up calling medical control, and they gave us termination orders, but we had to work it because it wasn't fully signed out. It wasn't a full legal order. It can come in a variety of different ways. It could come in the form of a wallet version, but usually, they'll carry this in their wallet, but their actual one should be somewhere nearby. Like I said, you want to make sure that you can determine the validity of the document. Is it a true one? Don't just go based off of somebody's word. Okay? There have been cases in the past where families like, oh no, he has a DNR order, he's got a DNR order, and then they don't. And then we get in trouble. If you also want to make sure that you interpret it right, make sure you read these in full. And the family, you have a lot of times where the patient may have a DNR or some form of advanced directive and the family doesn't know it. So now if, patient's a DNR, family doesn't want it, they may hide that information from you. So these can be very difficult to handle. If you're ever in doubt, go ahead and initiate treatment and contact medical direction until that issue can be resolved. Like I said, in the situation that I had, they had the DNR. It was fully filled out except for that physician to sign it. So we initiated treatment, called medical direction, and then once we got the issue resolved, we ended treatment. Or not ended treatment, but we got the termination orders and stopped. At any time, a patient does have the right to refuse care. However, they have to demonstrate that they have the mental capacity to do so. So the patient has to be lucid, able to make fully rational and informed decisions. So you can to do this, have them say back what you did. They have word for word. Okay? If I say, sir, if you don't go to the hospital with me right now, there is a chance you will die. Make sure that they understand that and can say it back to you. If they cannot have any form of altered mental status, so they cannot be under the influence of drugs or alcohol. Okay, so if they are under the influence of drugs or alcohol, and they're obvious, they have slurred speech, they can tell that they're incapacitated in any way, they cannot make that choice. For capacity to be present, their patient has to be fully informed of the risks of going to the hospital, as well as the treatment that would be provided and the consequences of refusing that treatment. Make sure that you have them sign a release and have someone witness that refusal. That is your protection in case anything would happen. If that isn't signed and something happens to the patient, you as the provider is liable. So if there's a bystander there, have them sign it after the patient. If there's no bystanders available, have a law enforcement officer sign it. If that's not available, then have your partner sign it. Partner is always the last choice as for signing a refusal. So you want to make sure that you provide a good, thorough assessment. If pending they allow you, make sure try everything you can to persuade that patient to go to the hospital if they truly need to go. If they still don't want to go to the hospital, encourage them to seek help later. All right, if you don't go with me, I would still highly recommend you going to see your doctor later today or tomorrow. If you start feeling worse or if you change your mind, feel free to call us back. We're available 24 hours. We'll come back. We'll check you out. Make sure you document Document, document, document. If you didn't write it, it didn't happen. So make this is your protection in case anything should happen. All right, we're gonna take a break here. Stretch your legs, get something to drink, whatever you need to do. We'll come back in just a bit.